documents. I don't know where they are. I've never seen them. Again, there is no defense motion in the court file requesting that the July jury trial date be continued. Short of preparing a transcript of that entire Zoom hearing, I don't know how we're going to figure it out, but it wasn't at a formal request of the defense. And if it was continued again in June, because the medical records had not been produced, which were ordered to be produced back in March, that's a 4-month delay. And the state, in its lengthy motion that it filed on July 10th, acknowledged that the medical records had not been provided at that time because the state had concerns about those medical records being disseminated. So the state admitted on July 10th that it hadn't provided any medical records. So I don't see how that could be a defense continuance if the records hadn't even been provided. And from everything I can tell, the continuance wasn't requested by the defense.
You're talking about the original continuance back in March wasn't requested by the defense?
No, Your Honor, that one was. I'm talking about the July. Because
okay.
Ms. Gillett said the July was also a defense request because of medical records and transcripts and things like that.
Show of hands. Who thinks this is going to be a well thought out, truthful, articulate response to what he just said? Anybody? No? Nobody? All right.
Mr. House requested the continuance orally at the hearing.
No, I don't think he did. I think the judge, you know what? Don't listen to me or listen to her. Well, definitely don't listen to her, but let's see what happened. Here we go.
In this case, the defendant...
Well, I have control over your office, Mr. House's office, and the defendant, Mr. Walker. How does my jurisdiction and authority go further than that for things that are already let out?
Yeah, I would ask that he cease. He has now started a new Facebook page, him and his wife, to try to disseminate things. You can clearly see he's posting.
That's weird. I thought you never got on Facebook or you didn't pay attention to this, but it's weird that that's printed out and that where it would say somebody's name is blurred out right there on the bottom. That's weird. It's just trippy. You know, we can see that, but why is that all blurred out right there?
Bob Walker on that site over and over and over again, along with his wife. They're continuing to try to disseminate information about the case, make statements about...
Your response?
I technically don't think it's a problem.
Well, the court is going to enter an order precluding all parties in this case, which I think was contemplated earlier, from disseminating any further information about this case until the case has been tried.
I don't know. She said House entered his motion orally, but this sounds like a oral, verbal court order to not talk about the Robert Walker Jr. case. And I wonder if Jill could keep her fat ass mouth shut.
And completed. I agree that there's the potential interference with being able to get an impartial jury if people are trying to try their case in social media or making comments regarding various participants in the case while this case is pending. So in essence, this is a gag order on Mr. Walker, Mr. House, and Ms. Gillett and her office, and Ms. Gillett and her office, and Ms. Gillett and her office from further disseminating any material or information regarding this case. With the exception of scheduling information. And speaking of that issue, there is also a motion before the court to continue this trial, which I hate to do. I would like this case reach a conclusion and be over with. But in light of the late...
That would be on Jill or the state.
Late or certainly belated.
Belated and outdated, baby. That's what you are, Jill.
Certainly belated turnover of the medical records, which I think reach a critical issue in this case.
Super duper critical. Super critical.
In this case, by the state.
Absolutely. Late by the state, baby.
State. And failing to provide that to the defense in a timely fashion.
Yep. You hear that, Jill? You're a failure. He said you're a failure. You're a failing failure. You failure. You failed to provide it. Failure.
I think it's patently unrealistic to expect that the defense can be prepared for trial.
Patently unrealistic they'd be ready for trial because you're withholding the things that they need to properly defend themselves.
And be over
Let's hear that one more time without me interrupting.
with. But in light of the late or certainly belated turnover of the medical records, which I think reach a critical issue in this case by the state, and failing to provide that to the defense in a timely fashion, I think it's patently unrealistic to expect that the defense can be prepared for trial by next Tuesday. I will say, Mr. House, you apparently have been diligent in.
After hearing that, how could you possibly think that the time is going to be charged to the defense side? Give me a break.
Identifying your expert, you know where these records are eventually going to go, correct?
Yes, Your Honor.
Are you a bids appointed lawyer?
Yes,
Have you sought approval from? Are you a bids appointed lawyer?
yes.
Have you sought approval from bids for this expert?
I've not had contact with him yet.
Okay, you've identified him. All right. Well, you're going to have to act on that promptly with
Because
bids.
he's the doctor for Mrs. Walker. She has a back problem. She goes to a specialist in Tulsa, and he indicated he would be willing to look at medical reports and give his opinion.
All right. Tuesday, November the 5th, Mr. House.
Well, now what do you have to say for yourself, Gilbert Einstein? What other lies can you tell us? Go ahead. Continue.
At the hearing on, is it July the 18th?
Yes.
He had requested to have continuances to find a back doctor and have a second opinion and a review of the reports. No expert witness was ever provided, but Mr. House sought to have that done and even let me know it was the doctor of his wife's back
Yeah, we heard that. It was on the record, like I just showed.
doctor, the defendant's wife's back doctor that was to review all of the reports. And we talked extensively about the conflict of interest that it would be his wife's treating physician to be looking at the records.
Well, that must have been in private because it sure wasn't on the record. And what a coinky dink that the transcripts never came and that they never got the medical records. I mean, it's kind of like you planned this. But anyways, remember the part when Judge Ricky just said,
while this case is pending. So in essence, this is a gag order on Mr. Walker, Mr. House, and Ms. Gillett in her office from further disseminating any material or information regarding this case. With the exception of scheduling information.
well, wouldn't you know it? She started these proceedings on Lawrence accountability for a protective order, and she goes ahead and disseminates information about the case to the public, like she was told not to do. She violated a court order, a verbal court order from the judge right here.
Ms. Gillett, you mentioned that you didn't think Dr. Spees had violated the statute, the stalking statute, and that's why you didn't pursue any claims against him. Is that correct?
That's correct.
In that Walker motion, you did want lots of different relief against Mr. Irving and Lawrence Accountability and Dr. Spees and the other media people, right?
Anyone not complying with local rules.
But in terms of those, you wanted relief against them.
I wanted them to not videotape the trial.
You wanted the relief that you stated in that complaint, yes?
It's a motion, and there's lots of relief requested there, including increased court security.
That sounds like information to me because I didn't know that until she just said there was increased court security because of that. Looks like she's disseminating information to the public.
I got
And
it.
other issues.
I got it. So this will go a lot faster if you just tell me yes or no, and I don't have to keep asking the question.
Ironically, if you would have just said yes or no, you would have had a chance or at least an arguing point to say that you didn't violate this court order, but instead you decided to give up information like increase court security, you stupid
So I'll
idiot.
do my best to be direct if you'll do your best just to give me straight answers. Will you do that for me?
Then I'll start objecting as misconstrued questions.
All right. And in that Walker motion,
I love this lawyer.
you wanted them to be fined, Mr. Irving, expenses for change of venue. You wanted them restraint of speech. You didn't want them to be able to publicize. Is that correct?
There's numerous reliefs in there.
As far as what I said, are those things correct?
I don't know if it was specifically them fined, but the defense and or parties violating.
I can read it for you if it's going to be an issue.
Counsel, D has been admitted. I can read the motion.
Okay, and all I'm saying is,
Man, I would keep going, but there's numerous other times where she mentions it, but my phone doesn't have any storage and it's like 5 a.m, so I gotta upload this piece.